The topic is all about law on a business organization. According to my research, law on a business organization, which is refers to the legal framework governing or formation, operation, and discussions of various of business structure. So in the Philippines, the primary types of the business organization included of the sole proprietorship, partnerships, cooperation. So lahat po yan is matatalay po natin sa susunod po na topic na to. Law ng business organization. In the future, student of the tourism and hospitality industry need to establish their own business. However, in establishing the same, there are a lot of things to consider, such as the capital and location, among the others. So the example of this, for a student in the tourism and hospitality industry who would plan to establish their own business in the futures. So establishing businesses in the tourism and hospitality industry requires so careful to consideration. Key factors to consider is included, to secure sovereign capital, choosing the right location, and also crucial element. Other importance of that aspects beyond capital and location, most to also to be taken into account when the settings of a business. Three known forms of business organization. So first is a sole proprietorship, partnerships, corporation. So lahat po yan is matatalagay po natin yan, or ano bang ibig sabihin ng tatlo po yan. Sole proprietorship. A sole proprietorship is the oldest, simplest, and most prevalent form of the business enterprise. It is an organized business owned by one person. This sole proprietor is the personally liable. When we say liable, is mananagot for all the debts and the obligation of the businesses. There is no law of the govern there. These forms of the business organization, this law merely recognize the existence of a sole proprietorship. Other forms of business organization conducted for the profit by a single individual and required the proprietor or owner of a secure license of permit register the business name, the pay tax to the national government. Wherein there are no specific law or govern the sole proprietorship, the law recognizes their excess of the profit greetings business run by the individual. So, pag magpapatayo tayo ng mga businesses, so kailangan talaga natin na may license, and kailangan may permit yan to register talaga yung pangalan natin para ma-secure, and then of course may babayaran tayo ng tax dyan sa ating government. So that's all that is meaning of the sole proprietorship. Obligation of the sole proprietor. First is to secure license of the business, to register the business name, to pay tax, to pay personally all debts and obligation of the businesses. First is a secure license of business permits. Sole proprietor must obtain the necessary license of the permits to legally operate their business, typically from local government units and relevant regulatory bodies. Register the business name, while the sole proprietorship isn't a separate legal entity, the business of name. Of different forms of the owner names, most registered often with the Department of Trade or DTI in the Philippines. Pay tax, the sole proprietor is personally responsible for paying all tax related to the business profit, and there's no legal distinctions between the owners on the businesses of the tax purposes. Personal liability for debts and obligation is a crucial. So obligation is that the sole proprietor is the personally liable for debts and obligation to secured by the businesses, meaning personal assets can be at risk at the business face of financial or difficulties. Advantage of the sole proprietorship. First, sole enjoyment of profit. Second, the sole proprietor can decide to continue or stop the operation of the business anytime. 3. Law of capitalization. 4. Falling of tax is generally less complicated than cooperation. Disadvantage. First, personally liable to all debts and obligations of the businesses. Burdensome because all decisions and undertaking are to be carried out by the proprietor alone. Third, limited ability to raise up capital. Partnership definition concept. Article 767 of this new civil code property by the contract of partnership two or more and person by themselves to contribute money, properties, or industry to common fund with the intention of dividing the profit among themselves. Two or more persons may also form a partnership for the exercise of the profession. A partnership exists when two or more persons agree to place their money, affect, labor, and the skills of all commerce of the business, with the understanding that the share there shall be a proportionate sharing of the profits and losses among them. The most be clear our understanding a proportionate sharing of both profits or losses among the partner. Essential requisites of the partnership. There must be a valid contract. When we say valid contract, the partnership requires a legal binding agreement between the parties of involved. Number 2, there shall be contributions of their money, property, or industry to common fund. Contribution to common funds is a partners mostly contribute money, property, or the industry to shares fund of resources. The business object or the purpose of the partnerships must be lawful. Lawful business purpose is a business objects or the purpose of the partnerships must be legal, not against a public policy. The purpose of the partnerships is to profit and with the intentions on the dividing the sums among the partner. When we say profit motive and divisions of partnerships, the primary goal must be generate profit with explicit intention of distributing this profit among the partners. There must be two or more persons with the legal capacity to enter the contract of the partnership. Two or more persons with the legal capacity, there must be less two individuals who possess the legal ability enter the contract of partnership. Nature of the partnership. Just like at any relationship, partnership is based on the trust and confidence. Known for fiduciary natures of partnerships, these kinds of the relationship is a very important because the acts of any of the partners for upwardly carrying under their usual thread or business binds that the partnership unless the partner so acting has no authority to act for the partnership in the particular manner.
Good day everyone, my name is Justine Melad and this is my topic, Delectus Personae. The doctrine of Delectus Personae means no one can become a partner without the consent of all the partners. The doctrine of Delectus Personae dictates that no one can become a partner in a business without the anonymous consent of all existing partners. This principle stems from the inherent fiduciary nature of the partnership. Trust and mutual agreement are foundational. For example, Maria and Juan run a small tailoring business. Their friend Pedro wants to join, offering a large investment. However, Maria doesn't trust Pedro's business ethics, so she bought his entry. Despite the financial benefit, Delectus Personae protect Maria's and Juan's right to choose their partners. Partnership has juridical personality. 1768, partnership has the radical personality, separate and distinct from that one each of the partners. A partnership upon formation gains its own separated legal identity distinct from each individual partner. This means the partnership can enter contract, own property, and incur debits independently of the partner's personal asset. It essentially a new legal entity. For example, Anna and Ben from the partnership called AB Construction. AB Construction secure a loan from a bank. If a construction default, the bank can only pursue AB Construction asset, not Anna Ben's personal position. Conceivably, AB Construction profit belong to the partnership, not directly to Anna and Ben until distribute. Classification of partnership. Number 1. As to liabilities. Partnerships are classified based on liabilities. A general partnership holds all partners liable to the extent of their partner separated property after partnership assets are depleted. A limited partnership involves general partnership with a limited liability and limited partnership whose liability is capped at their contribution. Classification of partnership. Number 2. As to duration. Partnership can also classified by their duration. A partnership will has no fixed duration and can be determined at any time by the partners. A partnership for a specific period existing only for a determined time or to accomplish a particular task. Forms of partnership. As a general rule, since partnership is contract, it is a perfect form that time of the meeting of the minds of the partners. Therefore, partnership can be constituted in any form which may be oral or written. A partnership being a contract is protected when the partners agree. If partners contribute in involved property and contract must be notarized and include an inventory of the property, otherwise the contract is void.
Forms of partnership. Bullet number 2. If the partnership has a capital of 3,000 pesos or more in money or property, the contract must be in a public instrument and must be recorded in the Office of the Securities and Exchange Commission. Bullet 3. In case of limited partnership, the law provides that the parties must sign and swear to a certificate and that the word limited or LTD must be added in the partnership's name. Classification of partners. Capitalist partner is one who contributes capital, property, or money. Bullet A. A capitalist partner is not exempt to any losses. Any stipulation to the contrary is void. Bullet B. A capitalist partner cannot engage in other business which is of the same kind of business of the partnership. 12. Unless there is a stipulation to the contrary. Bullet C. The capitalist partner shall receive a share in the profit equivalent to the amount stipulated. If there is no stipulation, he shall receive a profit pro rata to his contribution. Bullet D. A capitalist is always liable for losses. Number 2. Industrial partner is one who contributes industry or skills. Bullet A. An industrial partner cannot engage in business for himself unless the partnership expressly permits him to do so, and if he should do so, the capitalist partners may either exclude him from the firm or avail themselves of the benefits which he may have obtained therefrom with the right to damages in other case. Bullet D. As for the profits, the industrial partner shall receive such BRM share as may be just and equitable under the circumstances. Bullet C. An industrial partner shall not be liable for the losses. Bullet D. While an industrial partner is not liable for losses, he or she may however be liable for any liabilities incurred by or the partnership from their creditors. Should the industrial partner pay, he has the right to be reimbursed from any payment he made. Number 3. Capitalist industrial partner is a partner who contributed both capital and industry. Bullet A. If the industrial partner contributes capital aside from his services, he shall also receive a share in the profits in proportion to his capital. Number 4. General partner is a partner who is liable beyond the extent of what he has contributed. Number 5. Limited partner is a partner in a limited partnership and liable only to the extent of what he has contributed. Bullet A. A limited partner can contribute only cash or other property but never industry. Thus, an industrial partner cannot be a limited partner in a limited partnership. Number 6. Managing partner is a partner who manages the business of the partnership. If there is no managing partner appointed, all of the partners shall manage.
Management of the partnership. The management of the partnership belongs to the person who either named in the article of the partnership or the partner appointed after the partnership has already been formed. In all cases, however, in the absence of any agreement, the management is vested in all of the partners. Number 3. Rule of there are 2 or more managing partners. If 2 or more partners have been entrusted with the management of the partnership without specification of their respective duties or without the stipulation that one of them shall not act without the consent of all the others. Number 4. Rule when the matter of management has not been agreed, all the partners shall be considered agents, and whatever any one of them may do alone shall bind the partnership without prejudice to the above-mentioned rule. Number 3. Rule. If there are 2 or more managing partners, if 2 or more partners have been entrusted with management of partnership without specification of their respective duties or without a stipulation that one of them should Rights of the partners. Number 1. The partners may associate another person with him in his share, but the associate shall not be admitted into the partnership without the consent of all the other partners. Number 2. The right to inspect and copy partnership book. Number 3. Right to demand a formal account as to partnership affairs, and number 4. Right to receive profit from the partnership. Distribution of profits. Under Article 1797 of the Civil Code, the profit of the partner shall depend upon the agreement of the partners. In case they fail to stipulate, the parties' share in the profit shall be in proportion to what he may have contributed. Profit of the industrial partner, insofar as the industrial partners in concern, he or she shall receive a share which may be just equitable under the circumstance of the industrial partner contributed capital aside from his service. He shall also receive a share in the profits in proportion to his capital.
Distribution of losses. The losses shall be distributed in conformity with the agreement. However, in the absence of stipulation, the share of each partner in the losses shall be in proportion to what he may have contributed, but the industrial partner shall not be liable for the losses. Dissolution of partnership. Dissolution is the change in relation of the partners caused by any partner ceasing to be associated in the carrying on of the business.
causes of dissolution without violation of the agreement between the partners. In contravention of the agreement between the partners, where the circumstances do not permit a dissolution under any other provision of this article, by the express will of any partners at any time. When the business becomes unlawful, when a specific which a partner had promised to contribute to the partnership perishes before the delivery. Advantages of forming partnerships. Number 1. It is easy to form since generally partnership is formed by more consent. Number 2. Easy to make a decision. Number 3. More capital is available in the business. Disadvantage of forming partnership. Number 1. The partners are liable for the actions of their co-partners. Number 2. Easy to dissolve. Number 3. If the partnership is unable to pay the debts, the personal assets of the general partners are liable. Number 4. Internal conflict or personal interest of certain partners is always probable. Republic Act 1123-2, the Revised Corporation Code RCC. On February 20, 2019, President Rodrigo Roa Duterte signed into law Republic Act 1123-2, otherwise known as the Revised Corporation Code of the Philippines, RCC. This law effectively repealed Batas Pambansa bilang 68 or the Corporation Code of the Philippines, which was approved on May 1, 1980. Corporation. A corporation is an artificial being created by operation of law, having the right of succession and the powers, attributes, and properties expressly authorized by law or accident into existence.
Attributes of corporation. Number 1, it is an artificial being. Number 2, it is created by operation of law. And number 3, has a right of succession. And number 4, it has express and implied powers. When we say management of the corporation, since a corporation is an artificial person, it cannot act alone, thus there should be somebody who should govern its affairs. And now we have the juridical personality of corporation and its commencement. Corporation is an artificial being. It is juridical entity that is separate and distinct from the persons who created it. We have doctrine of corporate entity. A corporation, from the moment it acquires juridical personality, becomes separate and distinct person from the person who created it. Now that is called the doctrine of corporate entity. Doctrine of person and the will of corporate entity. As mentioned earlier, a corporation has a personality separate and distinct from the persons composing it. Now we have the advantages and disadvantages of corporate form of business organization. Number 1 advantages is that it has a strong legal personality. Number 2, free transferability of shares. And number 3, centralized management. There is a board. Number 4, limited liability. And number 5, it has perpetual existence unless its articles of incorporation provides otherwise. The disadvantages is number 1, the process of forming corporation is complicated. And number 2, it is always subject to the control of regulation of the government. And number 3 is that a corporation cannot engage in business other than the business specified in the article of incorporation. We have the components of a corporation. Number 1, we have incorporators. These are the founders of the corporation. stockholders or members mentioned in the articles of incorporation as originally forming and composing the corporation who are signatories thereof. Number 2, we have the corporators, those that compose a corporation, the board of directors or board of trustees, stockholders or members, including the incorporators. We have the number 3, stockholders, members, persons who own or holders of shares or stock in a stock. We have the corporate officers. Number 5, we have directors and trustees that manage the affairs of the corporation and exercise corporate powers. Number 6, we have independent director. These are the person who, apart from shareholdings and fees received from any business or other relationship which could reasonable be received, to martially interfere with the exercise of independent judgment in carrying out the responsibilities as a director. We have the corporate term. So when we say perpetual, it continues existence unless its articles of corporation in the revised corporation code, a corporation now has provide otherwise. So when say one person corporation or OPC, a one person corporation is a corporation with single stockholder, provided not only one natural person, trust, or an state may form of one person corporation. We have the components of one person corporation. Number 1, director and president. The single stockholder shall be the sole director and president of one person corporation. Number 2, we have officers of OPC. The one person corporation shall appoint a treasurer, a corporate secretary, and other officers as it may deem necessary. And then we have the nominee and alternate nominee. One person corporation or OPC until the legal heir of the single, the nominee shall sit as director and manage the affairs stockholder have been lawfully determined, and the heirs have designated one of them or have agreed that the estate shall be the single stockholder of the OPC or one person corporation.
We have 12 classifications of corporations. We have stock and non-stock corporation. A stock corporation gives shares and profit to investors, while a non-stock corporation does not. And then we have public and private corporation. A private corporation is for personal or business use, while a public corporation is created by the government. And here we have corporation de jure and corporation de facto. A de jure corporation is legally complete, while a de facto one is legally de facto but still operates. Corporation by prescription and domestic corporation. A corporation by prescription is accepted by long-time use, and the domestic corporation is formed under Philippine law. Foreign corporation and a corporation sole. A foreign corporation is formed abroad but allowed to do business in the Philippines, while a corporation sole is religious leadership. Eleemosynary corporation and a one-person corporation. Eleemosynary corporation is for charity, and a one-person corporation has only one owner. The powers of the corporation. It's all about express powers are clearly given by law. Incidental powers are naturally included, and implied powers help carry out the others. The dissolution of corporation. Dissolution means ending corporation's legal life, either voluntarily or involuntarily, or through expiration of its term.